Welcome back. My name is Mark Dighton. I'm the Director of Law School Relations and Administrative Director of the Patent Office Exam course for an organization called PLI. Stands for Practicing Law Institute, but we generally go by PLI in the business. We're a nonprofit organization founded almost a century ago that does educational programs for attorneys and related professionals. And I run one of our most important courses that teaches people how to pass the patent office's registration exam. But in this segment, we're just going to be talking about what the work is like for patent agents, talking mostly about patent prosecution, which we'll define in a minute, but just to give you a sense of whether this is the kind of work you'd be interested in. It's the second series. We're going to get later into how you find jobs in this field, what being an agent is like versus being an attorney, and then what the exam is like if you decide you want to pursue this. We see engineers and scientists employed in the field of patents in all three of its main branches, but mostly in one. So let's get the other two out of the way first, pretty quickly. First is litigation. Patent litigation makes a lot of headlines. If you're reading all about patents, it's probably patent litigation because it's often big companies going after each other for sometimes millions, maybe billions of dollars. Litigation work is very intense and very dramatic. You will pour your life into it. You may have to pick up your life and move to Cleveland for a couple of weeks to a month while a case is being litigated. Patent litigation is notoriously long and torturous. It's often long hours, too. If something unexpected comes up at the trial, the judge is going to say to you and your team, I want a 50-page brief on my desk tomorrow morning at 8 a.m. discussing this issue, and you and the team will spend the whole night up and poring over this and getting something together to have on the judge's desk first thing the next morning. It's for people who like that drama, who like that theater, who like that excitement, the sort of type A personalities. But that's not for everybody, and often not for engineers and scientists. The second field that's becoming bigger is what the lawyers would call the transactional world, the buying and selling of intellectual property. And here, it's kind of always really mostly patents in the first place. And in the patent world, you rarely hear, well, I would say rarely, but it's not as common to actually sell a patent to somebody. You're more likely going to license it. License means you're giving somebody the right to use your invention, but not giving them the ownership of the invention. So you still have you retain some rights to that invention, to own it when they're done, or maybe to give a license to someone else to use your invention. Depends on exactly what the situation is and what kind of contract, what kind of license is going to be drafted to cover what the parties need or want out of the process. So licensing people are mostly operating in the business world, kind of as opposed to the science or engineering world. You need to understand you need to understand the practical implications of the technology. Who would be most interested in this new invention, this advancement in the technology? Who would stand to make the most money? And then you need to be able to help figure out what the appropriate scheme is, often involving complicated royalty calculations, maybe the forfeit of the license if the person uses it wrong or fails to make enough money off of the invention to get you the money you thought the invention is really worth. With litigation and licensing, though, you're always going to be working with an attorney. An attorney is really going to be the person handling those forms of work, and they're going to need a technical person to help them understand the technology, and you're going to be that person. But the trouble is you're always working for an attorney then, and I'm an attorney, so I guess I have the right to say I wouldn't maybe wish that on my worst enemy sometimes, especially litigators. Can be very intense, egocentric people. But if you've got a head for business, if you're interested in the business applications of technology, then licensing might be a great place for you to be. I should talk a little here about tech transfer. assuming you're at a university, you may have heard of the technology transfer office at your university. That's a fairly new field that's kind of coming up and really becoming a major player in our field. Tech transfer involves the university owns whatever research the professors and others students are doing at the university, and so the university will often license whatever kind of invention professors or research assistants have come up with to commercial entities to make some money off the thing, and some of that money comes back to university. That really has only existed maybe 10, 20 years at this point, and is really becoming a major factor, a major player. So if you're there at the university and you're thinking you want to kind of just dip your toe in the water, then one of the things you should do is go reach out to your tech transfer office. I can help you find them if you can't find them yourself. I should have mentioned at the beginning, if I didn't, my email address is mdighton, mdighton, @pli.edu. Send me a question and I can help you sort some of these things out. Where we really see most engineers and scientists employed is in the field of what we call patent prosecution. And the nice thing about that is that engineers and scientists, after they've passed the patent office's registration exam and can call themselves patent attorneys, patent agents, you can basically represent clients on your own. You'll probably be working with some attorneys, but you're not just working for an attorney. You can have your own clients and your own cases. You can be representing these clients in front of the patent office without an attorney being involved. So it's one place you get some real autonomy, and you get kind of your own cases, your own clients, and all that kind of stuff. If you pass the patent registration exam, you're basically representing clients at the patent office, like an attorney would represent a client in front of a court, basically helping them to get a patent. We call it patent prosecution, and that makes some people sort of nervous, but it's not like criminal prosecution. No one's ever going to jail over this. It's called prosecution basically because criminal prosecution is the government coming after you for something bad you've done. Patent prosecution is kind of the reverse, but it's you kind of versus the government. We don't like to think of it as versus. It's you working with the federal government to get something from the government for your client. Once you pass the patent office's registration exam, you can, in theory, go out and find clients on your own. People who will, who want patents and will pay you to help them get a patent, and handle them on your own. But those people are hard to find unless you're really well connected in the right places. And essentially, more importantly, the only people who will hire you as a solo patent agent with no real experience in getting other people patents are going to be, kind of what we call the crazy garage inventors. Who are the people who are just doing this on the side while they're got a primary job doing something else. And the trouble with them is they will never pay you. Even if you actually get them a patent, their attitude will be, well, you didn't really do anything. I did all the work. I'm keeping all the money. And patents are very expensive and very difficult to obtain and maintain. So no serious player is going to go out and hire some newbie who just passed the patent office exam, even though they technically could represent them. No matter how kind of good your credentials are, no matter how good your degrees are and where they're from, you probably really need 10 years of experience before you have enough skills and clients to go into business for yourself. And then you can. A lot of people do that, and that works out very well for people. But you really got to start at a law firm or a corporation, essentially in their kind of patent department, where you will like an apprentice, learn how these things are done at the hand of somebody who's more experienced than you are. You go work for a law firm or corporation, and you will be assigned a case, an invention that you're going to go get a patent on. You'll get some paperwork describing the invention. If it's not clear, you may have to call up the inventor or inventors. And so one of the things I'll say here's a sideline here is a Often a familiarity with foreign language can be very helpful here. More than half of U.S. patents start overseas. They are someone filing for Chinese, Japanese, Korean, Indian. I mean, you name it, and somebody's probably filing for patents in the U.S. Where the inventors and all the paperwork may well be in a foreign language. So kind of tuck that in the back of your mind if you've got a foreign language fluency, especially if the technology aligns with kind of what's hot from those countries. You know, if you can speak and read Korean and you're in electronics, if you can read Hindi and you're in, you know, biopharma area, if you can speak and read Mandarin and you're talking about mechanical engineering, there's got to be that kind of nexus, obviously. Okay, so let's say you've got the case, you've read the paperwork, you've got a sense either just from the paperwork or from talking to the inventors what exactly is new and different about this invention. It's got to be new and different or you're not getting a patent. That's what patents are for, something new and different. The first thing you've got to do is make sure somebody else doesn't already have a patent on this. Just because, you know, nobody's seen it out in the market doesn't mean there isn't a patent on it, which just no one's been able to sort of capitalize upon. So you'll search what's called the prior art, which is a term of art that just means previously granted patents in that field for anything that looks like the case or invention that you've been assigned to. It's not like looking for a needle in a haystack. This is all a very organized system. All U.S. patents are classified into what are called art units that are very specific slices of technology. So one of the first things you'll do is figure out, okay, which art units would this invention be classified in? And then you're going to go search those art units for similar patents. You know, using key technical words, chemical diagrams, whatever else is appropriate under the circumstances. Every once in a while, you may find something that sounds exactly like the invention, the case you've been assigned to. At that point, you'll probably have to go back to the inventors and say, I found this patent number, you know, whatever, XXXX, that sounds like what we're talking about. Am I missing something here? Every once in a great while, the inventors may say, oh, geez, you're right. And that's it. You're dead in the water. Somebody's already got a patent on this, and probably those people are going to have to go talk to the people who already have the patent and figure out there's some way they can't work out a deal to actually go make some money off of this thing. More likely, the inventors you're working with are going to say, no, that's nothing like what we've done here. What we've done is completely different in that the way we're accomplishing this is better, whatever. It may be a very small distinction, but you've got to recognize at the same time that it may make a very big difference, especially to the inventors themselves. They may have spent years devoting their lives to discovering a way to work around this problem that no one else has ever been able to sort of solve. You know, maybe they've just figured out a process by which, you know, a new, unique way to accomplish something that makes it, you know, 0.1% more efficient than everything else that's existed in the field up until then. But recognize that in certain fields, that 1.1% efficiency may eventually make someone millions. So you've got to be able to sort of understand what they've done, what's different about it, how important that is, in order to really kind of appreciate what they're doing and to go do a good job for them. But even if you don't find a patent that covering that invention specifically, you still have to know what the similar patents are, because you're going to have to draft your patent claims, your patent application, to avoid overlapping all those other patents that have all been granted. In theory, you can't have any overlap between any two patents, so you're going to have to craft something that's going to very closely map out what the inventors have accomplished without overlapping on any existing patents. So now you get it. Your job is to put into words what is new and different about this invention. The heart of the patent application are the claims. Here's where you'll describe specifically what is new and different about this invention and how it works. You're going to start with some very general language, and then in the claims, tell the patent office specifically what this is and how it works, and in the process, kind of what's new and different about this. You'll have to think very creative about what they've accomplished. You don't want to sort of think that, okay, I'm just patenting exactly what they've done, but you want to try to give them as much patent coverage as possible. So you're going to take and look at what they've done sort of conceptually and just say, okay, not this particular chemical compound, but could other chemicals similar to this also work? That kind of thing. Can we find some similar way to accomplish the same goal? If so, you should be writing a patent to cover that so that somebody can't come and do something very similar to what your inventors have done and get away with it, be able to basically accomplish the same end by a very similar means without having to pay your inventors anything. So you're going to want to describe, the invention at every turn as generally as possible to give them the broadest scope of coverage. You'll probably have to check with the inventors on some of this, unless you're really up to speed on their technology. And they hopefully will say, oh yeah, that seems like that would work, or they may say, oh no, that won't work because, and then you've got to remember in writing the patent to use a word that would exclude whatever it is that we know won't work. And you've got to, again, be cognizant of drafting the language in a way so as not to overlap, in theory, on any of the prior art, any of the patents already granted. So if you're doing your job really well, you're going to think through every aspect of the invention, really understand it and how it works, and come up with ways to describe every aspect of it as broadly or generally as possible without, again, encroaching on other patents or things that make the process, the patent, not work. And so that's what you're going to write as your claims in the patent application. You'll send that off to the patent office, where it will be assigned to an examiner in that art unit. The examiner will do what you did. They're going to go look at the prior art for any patents that overlap on what you're claiming in your application. And they may not have to do that much research. Think of what that examiner does all day. They're looking at the cutting edge technology in that field every day, in and out. If you've done your job well, they can probably look at what you've written and see exactly what's new and different about this. But if you haven't done your job well, it's not their job to write the patent claims, the patent application for you. It's just their job to say, no, I'm not going to accept that. Likely they're going to find some of the patent or patents that are similar to what you're trying to get a patent on, and most likely they're going to reject you offhand based on that patent. Maybe it's the patent you first found and thought was a problem, but the inventors explained it away. If not, it might be something that's only sort of vaguely similar. To some degree, you've probably asked for it because you've written that patent so generally, trying to cover as much territory in this concept as you could possibly get away with. And so they're going to have to sort of rein you back in a little bit. So you're going to look at what they say and say, yeah, I get it. I knew this was going to be a problem, but, I was just trying to see what I could get away with. They won't fault you for that, and you shouldn't fault them for doing their jobs likewise. So you're going to recognize they have a valid point. You're going to have to go back and search for terms or language that will give your client the broadest possible protection without overlapping on any other patents. And here's where we find the first skill that will make you happy and successful in this field, and that's you got to kind of love to think about and play with words. Now, I'm not talking about poetry here or even prose. I'm talking about technical words. But you have to love thinking hard about technical words and what they mean, and whether the words are similar but broader or narrower, depending on the circumstances. and you may, have to do this to some degree on your own. Most likely work at a law firm or corporation. You're going to have a team of people you can kind of work with. You can go bounce ideas off of, ask them for words that might help you out of a particular bind. What about this word? What about that one? If you're working in a law firm or a corporation that specializes in one, fairly specific area of technology, you'll likely have people who can really help with this. You may even have someone who will say, oh yeah, I've worked with that examiner. I know what she's like. Here's the kind of thing I know she hates. Here's the kind of thing that's worked with her in the past for me. Why don't you go try that and see if it works? So one way or another in this process, you're going to come up with some language to address the examiner's objections, and you'll submit a amended language to try to address those issues. They may reject that language too, either because you didn't do a good enough job avoiding the patents, or maybe you've now started to overlap on another patent. But frankly, this process goes back and forth for months, sometimes years, in some rare cases. But keep in mind, the good thing is that the patent office is not usually demanding a quick turnaround. It's not like the judge who says, I want something on my desk tomorrow morning. The patent office is going to take their time looking at whatever you send them and considering your claims, and they'll usually give you 30, 60, maybe 90 days to respond. Now, likely you'll want to get it done sooner to show the client that you're doing your best for them. We had 60 days to do this, and we did it in 20. Something like that. So, you'll impress them that you're really doing a good job for them. But, the trouble is you still get the patent office on their end taking their own sweet time, stretching out the process. So one of the many, one of the issues you'll have in dealing with clients is, they're always going to be asking, what's happening, what's happening, what's happening? And one of your common responses is, well, we're still waiting to hear back from the patent office on that. And if they've got any experience in patents, they're going to know, yeah, that's just the way this goes. As long as it's not like, well, we haven't done our part, they're probably going to be fine with that. But probably eventually, more than 2/3 of the filed patents, are eventually a patent is granted, and probably that patent is going to be pretty close to exactly what you thought you were going to get in the first place, and hopefully what the client knew they were going to get in the first place. They hopefully know what the other competitors are doing, and that we have to kind of avoid those things. They know their technology and the businesses. Occasionally, you're going to run up against a very difficult examiner who is not going to give you any patent, or maybe a patent that is only so narrow and specific that's really not worth the money that patents cost. Again, patents are very expensive. If that arises, you probably have to go back to your bosses, and they'll confer with the client and decide whether to ban the effort or to get more aggressive about it. If they decide to get more aggressive about it, they're probably going to give the case to an attorney. Now, attorneys are not necessarily going to know more about the patent office or the technology than you. In fact, they probably know less. But, to some degree, attorneys are by nature or by training more aggressive. So in some ways, that's a good thing for a lot of agents. They're not really comfortable with that. If it gets ugly, an attorney's going to take it over and going to fight the patent office about it, and maybe even sue over it, although that's very, very rare. So by now you've probably figured out that you're not just working on one case at any given time, or you'd spend a lot of time just sitting staring at the walls. You're always working on a number of cases at a time. Depending on where you're working, it could be 20, 30, 40, or even more, depending on how busy the firm or corporation is and what the work is involved on all these patents. But don't worry, you will not be left to your own devices to manage this. Any serious firm or corporation will have what's called docketing software that will keep track of what cases have been assigned to you, what's due next, how long the software thinks that you will have to spend on it. So every morning, basically, the software will tell you, unless there's something else I don't know about, here's what you're doing today. So you'll always have a caseload of many cases, many of which are just going to be sitting on your desk waiting for you to hear from the patent office, or waiting for you to get done with something else more pressing. But, given the patent office always gives you plenty of time for turnaround, your work will always be pretty predictable. There will be no surprises. You just have to, with due diligence, kind of proceed through all of your cases and make sure you get the work done. Working law firm is often longer hours, but for more money. But if you're paying attention, heeding the software, and factoring anything special the software doesn't know or can't account for, you'll rarely have to give up weekends or vacations to get your work done. And that's one of the major ways patent prosecution differs from litigation and licensing, which we defined in an earlier video. Litigation and licensing can be very intense and demanding of your time. You may have to put everything aside for weeks at a time when a deal is coming together or you're preparing for trial, and litigation has the additional burden that you have to fly to Pittsburgh or something and live there practically for weeks or months while the patent case is being tried. But that's also why sometimes you're going to make more money in those positions, because they are more difficult to handle as a practical matter. Prosecution is very orderly and very scholarly, very serious, but doesn't have the high-stakes drama of litigation or licensing. And for a lot of people, that can be a plus, right? You just got to know what's right for you and find the position that suits your temperament and your skills. In the next video, we're going to be talking about, hopefully you're a little bit interested at least, where you find this work, okay? So I'll talk to you then. Thanks.